Okay, here we are. We're just getting underway. We have a live question and answer about the Bill Cosby hearing today. So far, we've got one person that's joining in. Let's get a few more folks on board and we'll get underway. All right. So today we had a very interesting day in court regarding Bill Cosby's very unusual hearing where the former district attorney has testified that he definitely is not on the team of the defense. However, he is absolutely 100% certain that his unilateral decision that he made back in 2005 not to prosecute Bill Cosby binds the hands of the current district attorney. In fact, he believes that the decision that he made on his own, without any participation from Bill Cosby's lawyers, somehow means that there is an immunity agreement between the parties. He, I believe, in my opinion, does not understand the law as it pertains to immunity agreements. A prosecutor's one-sided decision to not go forward with a case due to practical or legal reasons means that that prosecutor is not going to bring any charges, but that doesn't mean they can't change his mind. The prosecutor in 2005, it's important to note, makes some of the same observations that I made, because in the absence of any other evidence corroborating the statements of Ms. Costan, all you have is a swearing contest, essentially, by the only two individuals who were present in the room. It's interesting to note that Ms. Constant made her police report 1 year later. Bill Cosby also cooperated with the police, and he went down and he gave a statement, and he said exactly everything that she said except for the issue of consent. He alleged that they did have the sexual contact, they did not have sexual intercourse, but that to the extent they had sexual contact, that there was consent. So this all boils down to the issue of consent. So today, the defense, to set this up, has made a motion saying, look, we're entitled to pretrial immunity because there was this agreement. So that's the issue for today. It's not whether or not Bill Cosby's innocent or whether he's guilty, but it's about whether or not he had any immunity from prosecution. There are two different types of immunity that are important to understand. The first is known as transactional immunity, and essentially, if Bill Cosby had transactional immunity, he would forever and ever be protected. No prosecutor ever could come back, even if it's within the statute of limitations, and prosecute him. The other type of immunity is known as use, or sometimes referred to as derivative use immunity. And that means that as it pertains to the Cosby case, the prosecutor could have granted him immunity to the extent that anything he said in the civil depositions would not be admissible, nor could anything that was derived from that be admissible in any future criminal prosecutions. The defense has set this out as an agreement not to prosecute. The initial DA now says it was not a quid pro quo. It was a unilateral decision that I made. My intention was to bind the state forever and ever from going after Mr. Cosby so that we would induce Mr. Cosby to participate in the deposition. Mr. Cosby did participate in the deposition, as we know, and as testified by Mr. Castor, the former DA, Mr. Cosby would be a fool to have answered those questions without some immunity. So that's where we are, and that's what sets this up. Lots of questions are and have been raised. Does this announcement, this unilateral decision, amount to an immunity agreement? In my opinion, I think not. And as Mr. Castor concedes, there was no agreement by Mr. Cosby to do anything whatsoever in exchange for that announcement. So I think the way this is heading is that although Mr. Castor believes he granted some type of immunity to Mr. Cosby did not have immunity. Unfortunately, the lawyer for Mr. Cosby at the time is no longer with us. He has since deceased, so we will not have his explanation about why he permitted Mr. Cosby to answer questions at a civil deposition without a written, ironclad guarantee of immunity. We also don't know why Bill Cosby went down and gave any statements to the police in the first place. That's where I really come off the train tracks here. I don't understand why a lawyer would take Bill Cosby down to the police department and say, yes, everything Andrea Constand said is true, except for the fact of it was consensual. Interestingly, Bill Cosby did say to the police that he gave her medication that he described as being Benadryl, and that according to his own statement to the police, this is well before the civil lawsuit, he was well aware that Benadryl put him to sleep almost immediately. So I have publicly stated, and I still think that even without the deposition testimony, Bill Cosby's statements to the police alone at the very initial police interview might be enough to convict him, especially if you bring in all of the later witnesses and the similar transaction witnesses that have come forward that said he did something substantially to them. So let's get to some questions. Looking here at the Periscope feed, people are pointing out that they were friends with a touch of romance. I've looked at the police complaint, and I think that there is some truth to that. There was, even after the allegations of the assault that took place in January or so, maybe February timeframe of 2004, there was, according to all the police reports anyway, and the police charging complaint, there was some type of relationship that continued between Mr. Cosby and Ms. Constance. She went to his home in Pennsylvania. She went to his home in New York. She met him at a casino. There was lots of phone calls back and forth, and I think that was what the former DA was talking about today when he said there was some credibility problems. There were some things that she did, some ways that she was acting that were inconsistent with someone who's a victim of a sexual assault. Now, I'm not making any statements. I don't know how someone who's been the victim of a sexual assault is supposed to act. I certainly wouldn't pretend to make a judgment on that. But I'm just repeating what Mr. Castor said. And I know that if there were a trial, her conduct following the alleged assault would certainly be fertile ground for cross-examination. There are also issues of the timeliness of the complaint. When did she come forward? Apparently, we found out today that one of the factors he considered was that she went to a civil attorney before she went to the police. So that comes into play. We have a very unusual predicament here because the initial DA thinks that he gave her immunity, but according to his own testimony, there was no quote-unquote agreement. The lawyers for Mr. Cosby were notified that he did not intend to prosecute, but that in and of itself is not an immunity agreement. So there have been another question has been asked for me to talk about the difference between transactional immunity and use immunity. Transactional immunity is blanket immunity. It means that you cannot be prosecuted at all, no matter what the evidence is, for anything that you've done, and it's usually done in exchange for something. Sometimes you see that where you have co-defendants seeking some type of immunity to testify against a co-defendant. Use immunity, you see where you want somebody to testify in a court proceeding, whether it's a civil case or a criminal case, but you still want to leave open the door that you could prosecute them. It's just that with the use immunity, you cannot prosecute someone using the evidence that you have immunized them from, in this case, the civil depositions. Castor has himself arguably made some inconsistent statements. He apparently emailed the current DA back in the fall of last year, 2 or 3 months before the charges were announced, and he said, you know, unless you can make a case against Mr. Cosby with something other than the civil depositions, you've got a problem. So it would seem that Mr. Castor believed in the fall that it was theoretically possible to prosecute Mr. Cosby, although he said that the prosecution would have to be done on something independent of the civil depositions. The question was asked, does it matter if it was in writing? The better practice is to get an agreement in writing that is obviously true in any kind of contract, and an immunity agreement is in the nature of a contract. But it's not necessarily required. If Mr. Castor had come to court today and he had testified, yes, I had an agreement, and the agreement was we would not prosecute ever if Mr. Cosby would agree to answer questions under oath in the context of the civil case. And if Mr. Cosby had said, yes, I agree to those terms, the establishment of that agreement could be made through the testimony of Mr. Castor. But unfortunately, it doesn't look, unfortunately for the defense, I should say, it doesn't look like they've quite carried that bucket of water right where it needs to be. Somebody's asking about the records of the deceased attorney. I don't know that we've heard anything about that. I don't know if there's any notes. We really don't know what evidence there would be. This is all presumably something that the district attorney would have looked into before announcing charges, especially in a case that's this high profile. Why would Cosby assume great legal counsel, not get it in writing? That is a very good question that I have yet myself to make any sense out of. I don't know why he would go and talk to the police in the first place. If he were my client, I would have said, I'm not going to dignify this with a response and leave it at that. He didn't have to go and talk to the police, but when he did, he corroborated every single thing that she said happened, all the way down to the touching, except to the extent that he denied that it was not consensual. He did say he gave her pills that, by his own admission, knew would put her to sleep, and that in and of itself could be enough to convict him entirely without using the deposition transcripts. One thing that Mr. Castor, the DA in 2005, did not know about was all the multitude of other accusers that have come forward. That information was, I don't think, available to him, at least not to the extent that we all know about it today. The issue someone posed about the pills were to make her relax. That is what he told the police they were for, but he also told the police that he knew that these Benadryl tablets put people to sleep right away because he was a regular user himself of those Benadryl pills. Let me just look over some other notes that I've got from the hearing today. The district attorney, the former DA, definitely says he wants the current prosecutor to win this hearing, although surprisingly he is very, very certain that there was no binding agreement between the parties. He doesn't remember whether or not he said anything publicly about the charges being weak. He said that all he wanted to do was to create an environment that would induce or cause Mr. Cosby to be able to testify in a civil proceeding, so that I think he said he was hoping he could help her become a millionaire. And so that was the essence of his intention. But he specifically said there was no quid pro quo, no give and take between the prosecution team and the defense team. Someone's talking about this being a money grab, to use someone's words, not mine. But there was testimony about Ms. Constance seeking some type of money from Mr. Cosby prior to going to the police. That all factored into the DA's decision at the time not to charge. We have, basically, in my view, we have a district attorney at the time in 2005 who believed that although he believed she was telling the truth, he didn't believe he could prove it beyond a reasonable doubt, and he would not bring charges, especially one of this nature, against a high-profile defendant unless he believed he could prove it beyond a reasonable doubt. He did mention publicly that there was some credibility problems. He didn't want to say that in public. In fact, he told the judge that he didn't want to say it in public, and there was a brief recess, and I think it had to come out publicly because we don't hold court in private in America, for the most part. Someone says, yes, there was some holes in her case, and there would be holes in her case, and I've written about that. There are lots of things that would make great fodder for cross-examination. She voluntarily went to his home on this evening after she alleges that he had, I guess, sexually battered her, for lack of a better word. There were at least 2 prior instances where he made some untoward, I guess, advances towards her, and she felt uncomfortable and left, but nevertheless she continued to maintain her relationship going over to his home. She admitted to voluntarily taking these pills that she didn't know what they were. She carried on a relationship with him after the fact. A relationship of some type. We don't know what it was, but it did include dinners at his home. So these are all credibility questions that the DA had. He did not have the benefit of knowing about the other accusers, and that, I think, is the difference between 2004 and here we're in 2016, here at the end of the statute of limitations. Is the case weak enough that no charges regardless for the DA? Well, the case, I think, if there's no immunity agreement, I think the case is strong, and the reason I say it's strong is because Bill Cosby's own words will be used against him. He establishes everything. He establishes that the conduct did occur, that she was at his home. All of the specific allegations, including the touching, those things did occur. He admits that. He admitted it to the police in the initial statement. He admitted it to the lawyers in the deposition. And he also admitted that he gave her drugs that he knew put people to sleep. You combine that with this parade of other women, could be dozens of them, that could come in and testify that he did substantially similar things to them. All that can go to show that he had intent to commit this sexual assault, and would be potentially enough to convict him. I don't think all of the accusers would necessarily be relevant and would be permitted to testify, but I think, quite frankly, a good bit of them would be. So if this motion by the defense is denied, it's going to be the subject of an appeal, obviously, at some point. Kathy's wanting to know, so those women can testify. There's something called prior crimes evidence. Usually we don't have people who testify about someone's character and whether or not you acted in accordance with your character on a specific occasion, but there's an exception for other crimes. If you believe that someone has a specific, I call it a criminal signature. If they do something the same way and it's so specific over and over and over again, yes, you can bring that in to show that someone does something not by mistake, but rather by design. Under the rules of evidence, we call that 404B information. So if anybody wants to do a quick Google search on the rules of evidence, Rule 404B is the rule that would be used to bring in the testimony of these women from other states, from the past, from all sorts of backgrounds that have essentially the same story. Now, it has to be credible, and it has to be so similar that it does bear the alleged criminal signatures to show motive and modus operandi. So that's where the other testimony would come in. I think this is at the end of the process. Probably it looks like not going to work out so well for Cosby's defense team to prove that there was any type of an immunity agreement. From the notes that I'm seeing from various journalists that I've been in communication with, and from looking at the public reports and trying to figure out everything that we can as far as what's happened in court today, it looks like the district attorney's office is probably going to carry the day. Mr. Castor, the former district attorney, is mistaken in his belief that Mr. Cosby could not have been prosecuted simply because he made a unilateral decision not to prosecute him at that time. And that's the most important thing, is at that time. And unless there was something that gave her more credibility, he wasn't going to go forward. So his unilateral decision back in 2005 is not going to be anything that's going to bind the current district attorney. So he's mistaken. I understand why he did not charge Mr. Cosby originally, but I don't understand Mr. Castor's understanding of the law. Okay, I respectfully disagree with him. I think that he does not have the authority to bind the current district attorney to anything. So, whatever questions you have now, I mean, I think court it may be back in session. Someone's talking about him being married and running around on multiple occasions. Well, that may be true. That doesn't make it necessarily a crime. That happens all of the time. It may make someone a bad person, if depending on what one's moral position is on that sort of thing. But it's not necessarily, well, it's not a crime, whether you're married or not. At least not anymore. So one thing is for sure that we know about Bill Cosby from his testimony and from his statements. He doesn't have the moral high ground that I think he wanted us to have. Viewer wants to know if the statute of limitation has run. No, it didn't. The statute of limitations would not have run until mid-January of this year, and of course they filed at the end of 2015. So they got in under the wire. And so even if these other women who have these claims, even if their criminal statutes of limitation have run in their various jurisdictions, they can still testify potentially in this case. The other big question that keeps popping up, and I don't want to repeat myself for those of you who've been here for a few minutes, it doesn't matter that this agreement was not in writing. It would have been better for it to have been in writing. It would have been more clear if it had been in writing. But it seems to be rather sloppy on the part of the district attorney at the time to simply make this press release saying, I'm not going to prosecute Mr. Cosby, and then assume that Bill Cosby is going to understand that to be an immunity agreement. Can the DA bring these charges even if it's before he took office? Yes, because these charges were brought before the statute of limitations. He was at the time, he was an assistant district attorney. The outgoing DA took, I guess, left office at the end of December, and this DA took office on January 1st. But he was still a prosecutor working in that office, and he had full authority to act on behalf of the district attorney's office at the time. He was essentially the DA-elect and was running the show, but in his capacity as an assistant DA. So that really won't have any effect on the charges whatsoever. What other questions can we get to before we check back in with the court? We've had a lot of interesting thoughts, and I've been trying to include those in my notes, and I hope I've gotten to everyone's questions. We're going to do this again. I think this is a very, very interesting legal issue. However, but at the end of the day, I don't think that Bill Cosby is going to be successful claiming that he had some type of pretrial immunity. What is the verdict? What is my verdict? Dismissed. I think the motion will fail. I don't think the judge is going to rule in Mr. Cosby's favor on this issue. Now, one thing that is important to note that could still derail the state's case, it's the issue of pre-charging delay. There is the idea that if someone is put in jeopardy of a conviction because the prosecutor waited too long to bring a charge, even if it's within the statute of limitations, that can be a constitutional due process violation. In this situation, Mr. Cosby would have to show that he has suffered some type of harm due to the delay. He's going to be hard-pressed to show that because for the last decade or more, he has been litigating this issue in civil court. So he knows all about what the evidence is. He knows what the allegations are. It's not like these allegations were sprung on him at the last minute and he hasn't had time to prepare. So he's going to have a hard time showing that his ability to defend himself in the criminal prosecution has been hampered by the pre-charging delay. Somebody says, let him be, he is 2 steps from the grave, and that is, a lot of prosecutors take that kind of thing into consideration, so do judges. If he is physically or mentally not competent to participate in his own defense, then he may have a ground to avoid standing trial right there. Many people have expressed a similar sentiment that due to his frail condition and due to his age and other things that he may not be physically or mentally competent to stand trial. That's probably something that we can see the defense bring up next, and that would be a good tactic. Try one thing, and if it doesn't work, try the next thing, and if that doesn't work, try the next thing, and if that doesn't work, try the next thing, and then appeal it all. So the criminal litigation could go on for years, and a man with in the advanced age as Mr. Cosby, that's a very practical consideration that all the people have to take into consideration. They certainly, whether it's real or imagined, he appears frail in court today. He appeared frail when he showed up for his initial charges in late 2015. Thank you all very much for tuning in, and I look forward to talking with you soon. And anybody who wants to keep up with this, I'm going to be tweeting about it. You've got my Twitter handle at Phil Holloway Esquire, ESQ, and thank you all very much. Have a great day.